Okay, so welcome everyone. Thank you for joining us. Thank you for being patient as we figure out our technical issues. I'm Jenna Anderson. I'm the Associate Director at the Center for Human Rights. Just for quick introduction, if you haven't worked with us before, our Justice Defenders Program coordinates pro bono legal support to frontline human rights movements who are facing slaps and other forms of intimidation aimed at silencing or undermining the legitimacy of their advocacy. So given the prevalence of the issue, we're really excited to see this increased attention. As we all know, SLAPPs undermine human rights movements, they chill free speech, but they also undermine confidence in the judiciary and the legal profession. And at their most extreme, they impact the actual independence of both when it comes to being protected from undue influence. So it really is vital that judges, prosecutors, lawyers, and their associations address this issue. And we're really delighted to convene this panel to discuss how we can do just that. So before I turn to our panelists, I think a few more people have joined. So just a few logistics. We are going to spend about the first half of this meeting webinar hearing from each of our panelists in turn before we move to Q&A. Each panelist has been asked to speak for approximately 7 minutes. In order to submit questions, if the audience members could use the Q&A function, we'll see them. I then will be able to pose those questions to the panelists at the end, and Spanish-English translation is available. You should see that option in your Zoom. Okay, so now to the substance. This morning, we are joined by Professor Margaret Satterthwaite, UN Special Rapporteur on the Independence of Judges and Lawyers. We are also joined by the Honorable Judge Fernando Henrique de Oliveira Biolcati. Apologies if I've mispronounced in any way. The Court of Justice of Sao Paulo, and also a Columbia Global Freedom of Expression expert. He serves as clerk to the presidency of the private law section of the Court of Justice of Sao Paulo, and also holds a master's and PhD in private law from the University of Sao Paulo. We are also joined by Charlie Holt, European lead for the Global Climate Legal Defense, or CLIDEF, and he is here representing the Coalition Against SLAPPs in Europe, or CASE. And we are also joined by our very own Zamira Jabarova, who is the Senior Legal Advisor for Labor Rights and Corporate Accountability here at the ABA Center for Human Rights. I am trying to go slow for interpretation. Americans tend to speed up, so I'm being mindful. I'd like to begin by asking Professor Satterthwaite to discuss her most recent thematic report under the mandate, titled Justice is Not for Sale: The Improper Influence of Economic Actors on the Judiciary. Professor Satterthwaite, could you please give a brief overview of the report's main findings and recommendations related to SLAPPs, and particularly any recommendations for judges, lawyers, and their associations?
Thank you, Jenna, and good morning, good afternoon, good evening, depending on where you are joining us from. It's lovely to be here. And I want to start by thanking the ABA Center for Human Rights, and especially Jenna Anderson, April Artrip, Lana Bayudas, and of course, Samira Drabova, as well as the panelists joining us today. And I also want to thank my colleagues here at NYU, Katerina Sidao, who made major contributions to this report, and also to Alucia Sonet, who did incredible work on the research. I also want to thank Melanie Santiso of the Office of the High Commissioners for Human Rights, whose work every day keeps the mandate afloat. So let me then dive into the report. This was my second report to the General Assembly, and as Jen, as you've already said, it's entitled Justice is Not for Sale, and its purpose is to examine efforts by powerful economic actors to exert improper influence over justice systems. Under international human rights law, judges and justice systems must be impartial, and they must be independent. They must provide equal treatment to all who come before them. However, judges and justice systems are vulnerable to efforts by economically powerful actors to influence and possibly control them. So, brief overview of what the report looks at. First, it defines improper economic influence, which occurs when economic actors like corporations or extremely wealthy individuals conduct activities using their powerful economic means that have or may be seen to have an improper influence on the structure of justice systems or the carrying out of the functions of justice systems. And this is all done with the apparent purpose of exploiting justice systems to further their specific aims. These activities then impact and distort processes that are designed to operate fairly and transparently to ensure judicial independence and equality before the law. My report is definitely not an exhaustive study of the issue. In fact, no mandate report of 10,000 words can ever be exhaustive, but it is intended as a wake-up call. It's really time for us to combat attempted capture of judiciaries and the misuse of judicial systems by powerful economic actors, including corporations and extremely wealthy individuals. The report examines a few exemplary avenues of economic influence, and I'm mostly going to talk about SLAPPs, but first let me just mention the others that are discussed in the report, and you can take a look at the report for more. First, organized efforts to influence who becomes a judge. Using economic means, actors lobby members of judicial selection bodies through lavish gifts, through events, and they also might create entities to influence or become part of judicial selection bodies. They are also using, when judges are elected, they use exorbitant campaign donations, often secretly, and that's, of course, something we're familiar with here in the United States. When judges are on the bench, undue influence can include paid engagements, such as speaking fees or engagement of judges as paid arbitrators or experts. And judges are also courted for post-judicial jobs by economic actors seeking to influence them while they're still on the bench. So let me turn now to SLAPPs. I present in the report SLAPPs as a stark illustration of an attempted weaponization of justice systems to serve private interests at the expense of legitimate human rights objectives. And I use three key elements to distinguish SLAPPs. First, an imbalance in financial, political, or social power between the powerful initiator and the less powerful defendant or target. Second, SLAPPs involve an abuse of legal tactics. It might include bringing disproportionate or excessive claims, using multiple legal cases, often in different forums or different jurisdictions, to maximize the impact on the target. And third, SLAPPs are targeting actions related to public participation and matters of public interest. And that includes free speech, free assembly, issues related to human rights or corporate misconduct, environmental damage, concerns around climate change. SLAPPs are a tool to silence criticism. A key finding in the report highlights the growing use of SLAPPs, and I'm eager to hear more about that, the kind of empirical side of things in terms of this increase. SLAPPs are especially harmful because they're designed to suppress legitimate criticism. Now let me turn to specifically the deleterious impacts of SLAPPs. So first, judges, lawyers, and prosecutors have a duty to uphold human rights norms, and SLAPPs are attacking those human rights. Specifically, they're trying to shut down freedom of expression, they're trying to shut down association and the free and transparent sharing of information, and they're also attacking those special activities and protections of human rights defenders. They can entail very serious consequences. People might be required to pay exorbitant damages and legal costs, have sometimes go to prison and serve lengthy sentences, and may also be stigmatized. I see that I have 1 minute left. So let me turn to recommendations. So specifically for prosecutors and judges, it's essential to use all available tools to identify and dismiss SLAPPs swiftly once they've been identified. If national laws lack necessary mechanisms, those gaps should be raised formally through professional associations, including judicial associations and bar associations. Prosecutors and judges should receive training on how to identify and handle SLAPPs. Lawyers' professional associations can establish ethical guidelines on SLAPPs, and they should consider defining SLAPP cases as sanctionable offenses. For states, enacting anti-SLAPP legislation and decriminalizing defamation are crucial first steps. States should also build a supportive legal framework with clear SLAPP definitions, early dismissal options, consideration of shifting the burden of proof to the SLAPP claimant to demonstrate why their claim should go forward, and modified rules of evidence allowing SLAPP defendants to present evidence concerning patterns of use of multiple jurisdictions or multiple filings against different defendants. States should also ensure free legal, financial, and psychological support is available to SLAPP targets. And I'm going to stop there because I know we have wonderful other folks to talk today, and I'm looking forward to the discussion. Thanks so much.
Thank you. And I quite frankly find it inspiring that you stayed on time because I was fully prepared for us to all go a little over. So thank you. And actually, that perfectly segues now to Judge Biolcati, who can talk to us about how this is working in Brazil and some of the specific ways that judiciary is finding to address these issues, even in the absence of legislation, which we know is something that is part of the recommendations as well. So with that, I will turn to the wonderful judge.
Thank you. Good morning, everyone. Good morning, good evening. So I would like to thank the American Bar Association for the invitation and express my gratitude, honor, and pleasure to be here with you discussing this challenging SLAPP issue. It would be hard speak just after Professor Margaret. According to a 2001 report by the Business and Human Rights Resource Center, of the 355 SLAPP cases identified globally, 73% occurred in Global South countries, with 39% in Latin America. This prevalence highlights the importance of understanding SLAPP cases in these regions to address the issue worldwide. In Brazil, there is no specific anti-SLAPP legislation. However, tools within the Code of Civil Procedure allow judges to manage such cases. The Supreme Federal Court, in its rulings on two actions with binding effects, recognizes the presence of judicial harassment when numerous lawsuits have been filed over the same facts in different jurisdictions with intent of or effect of intimidating journalists or media outlets, hindering their defense or make it excessively burdensome. In this case, the court determined that when judicial harassment is evident, the defendant may request consolidation of all cases in their home jurisdiction, and liability for journalists or media outlets is only established in cases of clear intent or gross negligence, such as overt failure in fact-checking. While these decisions are significant, they don't encompass all forms of SLAPPs, which may involve different dynamics, do not necessarily entail multiple lawsuits, and are not limited to cases involving the press. Recently, the National Council of Justice, which oversees and guides judicial conduct here in Brazil, issued recommendations on abusive litigation that could assist in managing SLAPP cases. Based on these guidelines and practical experience, there are a few indicators judges can use to identify a SLAPP case. One, identity of the parties. Plaintiffs often include politicians, public figures, government bodies, or large corporations, while defendants frequently consist of journalists, media outlets, activists, or NGOs. Second, nature of the claims. Cases often arise from defendants' opinions or reports on matters of public interest linked to the plaintiff's activities. Allegations typically involve violations of honor, reputation, or privacy. Third, repetitive litigation. SLAPPs often feature plaintiffs who file numerous cases on similar grounds against various individuals or entities. Identifying repeat litigants and certain law firms specializing in such cases can be a telling sign. Demand types. Requests for exorbitant moral damage far exceeding typical amounts for similar violations, or seeking injunctions to prevent further expressions about the plaintiff or related facts are common. And fifth, multiple claims on the same facts. Numerous lawsuits about identical events brought by multiple plaintiffs against the same defendant can indicate harassment. Of course, this is a non-exhaustive list, but it encompasses the most common characteristics of SLAPPs. When several of these factors are present, there should be a presumption that a SLAPP case exists, and judges should proceed with caution, applying relevant procedural tools. Although Brazil lacks specific anti-SLAPP laws, as I said, the Code of Civil Procedure offers mechanisms to deter abusive litigation and impose responsibility on plaintiffs engaging in abusive litigation. Here they are. When multiple suits involve identical facts, consolidating them in the defendant's home jurisdiction is advisable. Additionally, reviewing the initial petition to ensure the plaintiff provides a specific and concrete description of how their rights were allegedly violated and why this should prevail over freedom of expression is crucial, and the cases are subject to dismissal if this is not met. The burden of proof could also be reversed, requiring the plaintiff to demonstrate that the lawsuit is not judicial harassment. Preliminary hearings and other procedural checks may be employed to assess the legal validity of the claim and the plaintiff's good faith. Moreover, judges should avoid relying on expert analysis that might shift discussions away from freedom of expression concerns to technicalities that could unfairly benefit plaintiffs with a clear intent to harass. Sanctions, including fines and compensation in favor of the defendant for bad faith litigation or based on contempt of court, can be imposed on the plaintiff, while always respecting proportionality. Under the Brazilian Code of Civil Procedure, plaintiffs who lose may be ordered to pay litigation costs and attorney fees, even in case of partial loss, in proportion to the outcome. Finally, judges should inform professional associations about lawyers and firms engaged in abusive litigation. I think it's all for now. Thank you.
You all are just killing the 7-minute limit. Thank you very much. And really, thank you. It's very interesting to hear how judges are approaching, especially the identification and management of SLAPP suits as a fairly practical matter. I think sometimes we stay in theory, and so to hear the specific ways that they're identifying and the solutions and recognizing how to mitigate the harm is a big part of this. So thank you. And also, I always love a reminder that courts have tools they can use. This is part of what courts are supposed to be doing already, even if they don't have anti-SLAPP legislation. We're not asking for something new when it comes to this. So thank you very much. Now turning to another player, the legal profession, I'm going to ask Charlie to talk to us a little bit about the work of the Coalition Against SLAPPs in Europe, or CASE. And in particular, its focus on the role of lawyers who are bringing these SLAPP suits and some new proposed ethical guidelines that you all have been working on to address this.
Thank you, Jenna. Well, I'm feeling the pressure now to keep on time, so I'm going to kick off right away and try to keep within my 7 minutes. I'd just like to start by saying thank you so much for inviting me to speak today. And also huge thanks to the Special Rapporteur and to the ABA for what is a very important and, from our point of view, a very timely intervention on this important question of legal ethics in relation to SLAPPs. Both the note of the Special Rapporteur and the ABA's resolution call on lawyers to abstain from SLAPPs. And I hope in my contribution, we can flesh out exactly what that means in practice and obviously talk about it more in the Q&A. But first of all, by way of background, the Coalition Against SLAPPs in Europe, or CASE, has been mapping and analyzing SLAPP cases since 2019. Originally, we did this to identify the conditions that were giving rise to SLAPPs, and therefore the measures that were needed to decisively tackle the problem. But one of the trends that we quickly identified was that the same names of the same lawyers, of the same law firms, kept popping up in relation to different SLAPPs. Particularly in common law jurisdictions, we found that these law firms were in some cases boasting of their ability to shut down critical publications and activities, and in some cases, proudly advertising the aggressive tactics they were using to do so. In such jurisdictions, and I would include my own jurisdiction of England and Wales among them, oppressive legal conduct, I think, has become so normalized that it is in some cases an object of celebration, not of condemnation. And I say this because I think it underscores the scale of the cultural change, which is really necessary here, and why it is that we first set about undertaking this work. I should also say, at the same time, that we've recognized from very early on in the work that this is a thorny area full of nuance. Many of the lawyers within the legal working group of CASE themselves engage in public interest litigation. Many of them work for NGOs who are on the moving end of litigation as much as they are on the receiving end of litigation. And it is important to emphasize that public interest litigation is itself a form of public participation. And therefore, it is something that we should be working to protect. And we should be ensuring that there aren't any mechanisms in place that can be weaponized against public interest litigation. So we're fully aware, and have been from the beginning, of what a sensitive and delicate area this is. And that's really why the Legal Working Group of CASE launched its legal ethics work back in 2022. On the one hand, we wanted a clear set of standards that we could refer to in order to be able to identify and call out bad behavior. But we also wanted to provide constructive guidance to lawyers in order to positively engage and help them navigate the choppy waters of legal ethics. The final product, which I hope we will be launching in the next few months, consists of a comparative analysis of ethical codes and enforcement practices across Europe. It provides, in addition to this, a set of recommendations about how lawyers and indeed how bar associations can approach this issue. And it's these recommendations that I want to focus on today. Our report can be separated into two categories. On the one hand, we address efforts to facilitate the filing of SLAPPs. So that's a classic case where lawyers are assisting and enabling SLAPP litigants from filing their cases. But on the other hand, and this is something that Professor Satterthwaite said in her presentation, another area that we are seeking to identify and call out is the use of legal tactics to intimidate, harass, and drain resources. These are sometimes roughly called SLAPP tactics. Both of these, and I think when we're talking about SLAPP tactics, it's often easier to call out and condemn. But both of these areas can sometimes appear to run into conflict with certain prevailing assumptions about legal ethics. Often, though, I think these tensions represent a misunderstanding of the way that ethical obligations interact. So, for example, we recognize in the report and in our work that lawyers should not be identified with their client or their client's interests. But we do also say that they should be identified and held responsible for the tactics they employ on behalf of their clients. It may be true, and in many cases, an important principle that lawyers should not discriminate as to who they represent. But in terms of how they represent their clients, this is a different matter, and it's something that we should rightfully be investigating. When it comes to abusive litigation, this therefore requires due diligence. Indeed, we are careful to stipulate that our recommendations apply specifically in the context of SLAPPs. So it may be that some of the standards that we apply in relation to things such as procedural maneuvers are different in the context of other areas of law. Underpinning all of this, however, is the recognition that lawyers have a range of ethical obligations that they owe to a number of different actors. Their client, yes, but also the court itself, the justice system, and even in some cases, the other party. Lawyers may have an obligation to fearlessly, tenaciously, zealously, whatever adverb you want to throw out, to represent their clients. But they also have an obligation to the court. And this means not misleading the court. It means not advancing vexatious or frivolous claims. We note finally that where there is a conflict between different obligations, it is important to recognize that lawyers are custodians of the rule of law. and they should not allow themselves to become instruments of abuse. Where there is a risk that this is happening, precedence should be given to the court in the interest of justice. None of this should be thought of as a radical departure from existing norms. Nearly all jurisdictions in Europe prohibit abuse of process, and the majority of jurisdictions expressly recognize that lawsuits filed with an improper purpose are abusive. What we are calling for is for lawyers to recognize the full range of ethical obligations they have. And as I said, there is plenty of nuance here. And this is something we recognize and it's something we eagerly engage in. The report we will be publishing is the product of a number of consultations we have launched, and we hope once we've published to have roundtables following that with those who are involved. I very much hope it will assist to clean up this very messy area of legal ethics and to provide a practical tool for lawyers to navigate this area. I'll end there. Thank you.
Nailed it. Thank you. And thank you as well for the emphasis on we're not trying to shift, or your guidelines are not trying to shift the role of the lawyer. You're trying to provide guidance that helps them fulfill that role and recognize the full of that role. I'll also say your line about oppressive legal conduct being normalized really resonates with me. I think we are seeing that in various jurisdictions, but also in the US, I mean, that's we're the birthplace of SLAPP as a term. So this also resonates, as a US lawyer, this is something we've seen, and we do celebrate aggressive tactics here. And how do we celebrate being a good and zealous advocate for your client in a way that does not undermine the whole system of justice? So thank you. And I think that's a great segue to Zamira to discuss the new ABA policy, urging lawyers and law firms to avoid causing or contributing to adverse human rights impacts when representing business clients, in particular asking for them to engage in their business in a manner that's consistent with the UN guidelines, guiding principles on business and human rights. So Zamira, 7 minutes.
Thank you. Thank you, Jenna. And I would also like to thank the Special Rapporteur for the timing of this report to put the spotlight on the issue that we're all grappling in within the field of human rights. Charlie already set out sort of the nuances of around the role of lawyers with regard to SLAPP. So I'll just dive in and focus on the ABA resolution itself, which was passed just this last August by the House of Delegates at the ABA. And although it is very much explicit on the issue of SLAPPs, it has a broader focus on the role of lawyers in the context of the UN guiding principles on business and human rights, while as they advise their business clients. And that's and because of that, it has, in addition to SLAPPs, it has other 3 areas. And I would like to briefly talk about them because it shows how intertwined SLAPPs are with human rights. So it has four parts. One is the role of lawyers on advising their clients on applicable human rights standards in their business activities. That is broader than the due diligence requirements that we are now seeing in the context of the legislation that coming out primarily from Europe on due diligence requirements for businesses, which is sort of the second one where businesses are advised the human rights, applicable human rights standards for businesses as they set up their due diligence processes, as well as as they engage with stakeholders and as they set up the remedies for those who are impacted by adversely impacted by business activities. The third one is around labor issues. So it focuses both on sort of specific workplace requirements as well as freedom of association issues. So not engage in union busting, for example, as well as advising their clients on all standards related to forced labor and other labor rights violations. And the last one, the fourth one, is the issue of SLAPPs, where the resolution urges lawyers to abstain from engaging in SLAPPs. And the reason I wanted to go through all of the 4 sections of this resolution is because we wanted to make it clear how intertwined SLAPPs are with human rights. So engaging in SLAPPs violate human rights in many ways. The Special Rapporteur's report sets out those ways very clearly, both indirectly when victims of SLAPPs ability to have a normal life in terms of the access to food, housing, etc., is impacted, but also much more directly where SLAPPs actually target the human right of freedom of expression and association, and in some cases assembly. So there's that clear linkage, and we wanted to be clear about that. The other reason why this is important in the sort of UN guiding principles and the business and human rights angle is important is often lawyers operate as businesses. So law firms are businesses, and they're much more sort of, the obligations under UNGPs are much more clear for them. And the other thing I want to highlight on the resolution, which we'll post a link shortly, is the issue that the framing says engage in SLAPPs. So Charlie mentioned that, and a number of other speakers mentioned the SLAPP tactics being also covered. It's not just actually filing the SLAPP itself, but engaging in the tactics. So the terminology says engage in SLAPPs, so abstain from engaging in SLAPPs, and we want that to include the SLAPP tactics in addition to the filing of a SLAPP itself. And the report that accompanies this resolution references the Solicitors Regulation Authority of the UK that has come out with very clear guidelines on what those SLAPP tactics are. And actually the report references those and enumerates them. And in addition to that, the report has sort of a number of questions that the lawyers should ask themselves. And question number 8 actually says, as lawyers take on affirmative litigation, and especially if they know that on the other side, the defendant in that case is a watchdog organization or an individual, they should ask themselves, is this lawsuit going to vindicate a legitimate legal right? Or is the purpose of this lawsuit to burden a person or an organization that's trying to speak up on the issue of public concern? So sometimes people say that it is hard to identify a SLAPP, but if lawyers have that filter as they take on litigation, especially affirmative litigation, it's meant to serve as that filter to sort of identify those SLAPPs before they're even brought and to highlight the role of lawyers. So that's where I'll actually stop, and so that we have more time for questions. Thank you.
All right, well, thank you all very much. I do have some questions of my own, of course, but we've also been getting some in the chat, so I'll just sort of bounce back and forth. But that is why, if it looks like I'm looking at things, it's because I am going back and forth with documents and chats. So one of the first questions we had actually in the chat, which I think is a good ground laying question, is are there good tracking mechanisms for or publish information on the prevalence of SLAPP suits within a given country or against a certain set of defendants? For instance, we've heard journalists and environmental defenders, I think, are quite commonly associated with SLAPP. So is there data showing that for different types of defendants? And the poser of the question said they were specifically interested in understanding if it's possible to assess whether SLAPP suits against scientists have increased, decreased, or remained the same over time, which I think, as I'm reading that, I think that might link to some of the misinformation and disinformation issues we've been seeing just on a limb in the climate change discussion. So that's for the entire panel, but I do think, well, Charlie, I think you might have really good examples of how this work is done in terms of creating a database and a data set. So perhaps I'll ask you to quickly answer this in the context of cases work in Europe, but then I'd love to hear from the others specifically around this increase of SLAPPs against scientists.
I'll be as quick as possible on that one, which is that I would suggest, firstly, in the context of Europe, that you go to the case website. That's www.the-case.eu. And every year since 2022, CASE has been publishing a report or an update on cases in Europe. And that's been compiling a database of different cases that have been submitted to us. We now have 820 cases as of 2023. The 2024 report, I believe, will be published in the next few months. And there you'll be able to find a lot of the information. The database on which that information is based is not publicly on the website at the moment. But if you get in touch with CASE, info@the-case, I think you might have to check on the website, it might be contact@the-case.eu. That's the sort of data we can extract from the database. I know that Fernando mentioned the Business Human Rights Resource Center, their platform. I believe they actually do publish the database and can find that there too. Yeah, I'll end on that.
Thank you. Anybody else with some response on that question?
Not a direct response, but something that we have been advising in the context of the tracking databases on attacks against human rights defenders is to actually encourage the organizations that track attacks to have a specific tag for SLAPPs, and that has been growing. A number of national databases now track SLAPPs in the context of the attacks against human rights defenders. And they differentiate SLAPPs as a type of attack. For example, the Serbian database comes to mind. But it is true that not all databases differentiate by the targets of SLAPP. So specifically scientists, it would be harder to differentiate that, but that is also maybe an appeal to the broader audience, a number of whom are engaged in tracking SLAPPs, to start differentiating. There is a differentiation between environmental defenders, journalists, but scientists specifically, I have not seen yet.
Thank you. One of the questions I had as I heard you speak, and we've actually had quite a few participants kind of ask about the indicators. How do we know something's a SLAPP? We're putting a lot of weight in this term. This is a SLAPP, this is not a SLAPP. And I know that some of the recommendations in the report specifically say, use your tools to identify and dispose of SLAPP cases. That's the recommendation for prosecutors and judges. And similarly for lawyers, make sure you know the cases that constitute SLAPPs, advise your clients not to pursue SLAPPs. So I am curious about this identification, particularly in the absence of an anti-SLAPP statute, right? When we don't have a statutory definition. Is this challenging for lawyers and prosecutors and judges who actually might recognize a general obligation to prevent or mitigate SLAPPs, but then feel uncertain when it comes to treating a specific case as a definitive SLAPP suit? And I'd love to hear from all of you on that. I'm assuming, Professor Satterthwaite, this probably came up as you were getting information from folks. And I know Judge Biolcati, you had flagged that this is also a question you've had when it comes to ordinary persons. So if it's not the classic environmental activist being sued by the very large multi-billion-dollar company, how do we still recognize a SLAPP if it's an ordinary person, or an ordinary person maybe bringing the suit as well? So I will just ask Professor Satterthwaite first, then Judge Biolcati, and then of course Samir and Charlie. Always welcome your thoughts.
Thanks so much. Yeah, I think this is an incredibly important question. And I also think there's been an effort on the part of some to make it more complicated than it might be. So I just want to say that I do think that it is possible to identify SLAPPs. So, I define SLAPPs in a certain way in my report, and that's based on both the feedback we got, the submissions that we got, and then also looking at how SLAPPs have been defined in other locations. But one thing I will say is I think there can be no single definitive definition, in part because the purpose of a SLAPP is to exploit whatever is available within a given legal system. And so it's very helpful when there's anti-SLAPP legislation if it's good and effective. But I think hearing from the judge is going to be very important, because having judges simply do their normal job is really the key here. And prosecutors also, I think that's very important in places where SLAPPs involve criminal charges. One thing I do want to add before handing over. So there are these elements that you can look at, and my report sets out elements. And then of course, the Council of Europe does set out these indicators. I think one thing we want to avoid if possible is asking judges and prosecutors to look into the minds of the SLAPP claimants. So a high burden around determining what the intent is really going to be problematic. It's, I think, going to make it very difficult for judges to act deliberately and with required speed, and will make it very difficult, I think, also for prosecutors, unless they're finding unless it's easily on the face of the claim. So I would say that, generally speaking, you want to look at the differential of power, but that involves sometimes looking behind the single individual, because there can be individuals who are sort of bringing the claim, but there's a larger effort. So looking at that is important. We've already talked about exploiting different legal processes. We've talked about the aim of shutting down certain human rights. And I do think this issue of scientists is very interesting. So it might be science, it might not only be journalists or human rights defenders. And that there's a vexatiousness in terms of the way it has an impact. I'm not going to go into all of these indicators in the Council of Europe piece, but I will say that if looking at the Council of Europe indicators, just remember those are indicative, right? You don't need to find all of them. And then finally, a note of appreciation for the ABA, because I think that having lawyers associations define and articulate what the obligations of lawyers are is extremely important. And there, I'll hand it back over to you, Jenna. Thank you so much.
And Judge, I'd love to hear your response as well. Oh, you're still muted.
Sorry, I'm sorry. Yeah, I think it's harder to identify a SLAPP case when ordinary people are plaintiff or defendant. It's harder, but the core thing, it's, as Professor Margaret told us, it's the imbalance of power and the type of subject that is object of the action. So the action, it's based on opinions or expression of the defendant against the plaintiff. And another important thing, it's the clear disproportion about the remedies requested by the claimants. I think this is a key point to identify a SLAPP case as well.
Charlie?
I would just agree with a lot of what has been said, but one thing I just wanted to say briefly is that I don't think regulators or bar associations should be waiting for the passage of anti-SLAPP laws to tackle this issue or to define this issue. One thing I think is important to make a distinction between is the debate around anti-SLAPP measures in terms of new laws and the debate around legal ethics and the regulation of lawyers. Most anti-SLAPP laws worldwide don't define SLAPPs. They simply introduce a higher threshold for cases targeting public participation in order to go to trial. SLAPPs are, generally speaking, defined with reference to the purpose of the filer, and that requires a process of inference, which, as the Special Rapporteur has said, is something which can be guided through the Council of Europe recommendation. That is a separate process to that of an anti-SLAPP law, of a standard anti-SLAPP law, which is simply providing that additional layer of protection to acts of public participation. So I would say that first. The second thing I'd say is that in terms of the difficulties with making this judgment, and I appreciate it can be a difficult judgment call to make, but I would just go back to something I said in my presentation, which is this distinction between the facilitation of SLAPPs and the deployment of SLAPP tactics. I think that the latter is easier to call out. And that's the sort of thing where you can say some of the things have been said, a disproportion of resources or remedies demanded, for example, the use of procedural maneuvers to drive up costs. I think that's easier to call out and to condemn without even having to pass judgment on the case itself. The second thing I'd say is that, at case, we're not saying that every SLAPP should entail disciplinary action of the lawyers involved. So you could quite easily have a situation where a case is found to be a SLAPP through the process of an anti-SLAPP law, but at the end of it, there is still a decision that the lawyer is not culpable or shouldn't face disciplinary action. And that's because, we can, and I think what the precise standard of care that may be applied will depend on the jurisdiction in question. But we can, for example, say that lawyers should not knowingly or recklessly facilitate a SLAPP. And I think there's a debate to be had about what standard of care is applied, and that is then something which can be applied. And I would just say, and I will stop, that this is something which the Zamira mentioned, the Solicitors Regulation Authority in the UK. That's something that has already been identified by the SRA. So the updated warning notice that was issued to solicitors in the UK noted that lawyers have an obligation to conduct due diligence into the purpose of the filer. And so I think that is something that regulators can do without having to rely on statute.
Samira, did you want to throw in a remark as well, or?
Yes, I would like to just to note that I think the report by case also has this. There is an unsettled debate on whether there is a need for specific ethical guide or maybe specific rules or much more explicit guidelines on SLAPPs and lawyers' ethical obligations versus an interpretation of existing ethical rules that should encompass SLAPPs. And people have different opinions of that. And to be fully transparent, ABA resolution is also silent on that particular issue of how there isn't, for example, a call for disciplinary actions for lawyers who are engaged in SLAPPs in the resolution. It is a first step in sort of trying to change that narrative around when a lawyer advises a business client, the idea of zealous advocacy shouldn't mean to look at issues of SLAPPs or as well as labor and environment as just merely costs that need to be minimized for the purposes of increasing profits for the business client, but rather their obligations around complying with and upholding the human rights standards should be part of the advice that a lawyer gives. And there are plenty sort of rules in ethical rules that support that, including in the ABA's model rules. For example, Rule 2.1, where as an advisor, lawyer needs to include other factors and other overall sort of the legal context in which they're operating, as opposed to just looking very, very narrowly. Does this lawsuit have a merit, for example? It's not about just the merit of the lawsuit, but it's much broader than that. And I know I'm kind of digressing from the question, Jenna, but this was sort of to add to Charlie's point on sort of what are considerations at play for a particular lawyer as they advise their clients.
Thank you. Somewhat related, the next question we have is, what are the strongest or most prevalent arguments that are being made by defendants that you've seen in recent cases involving SLAPPs, particularly in countries without effective anti-SLAPP litigation legislation, I think. So yeah, what are the arguments that are actually working when someone is facing a SLAPP suit? Any example would be helpful. And Zamira and Charlie, since you're working with activists that are being slapped, maybe you have ideas on what's working?
I think I might point this to the ABA actually, because the one of the things that we've seen, which has been really interesting, is the development of case law around abusive process. I noted before that filing a lawsuit with an improper purpose is commonly understood to be a form of abuse. And so as I said, most jurisdictions in Europe prohibit abusive process and have different measures in place to be able to tackle abusive process. In some cases, including in England and Wales, it is possible to dispose of cases on that basis. The problem is that doctrine of abusive process is very underdeveloped. And so it needs to be built upon, and the sort of idea of a SLAPP as a form of abusive process needs to be fleshed out. We have some good cases that we've been monitoring, not just in the UK. There's and I'm going to get these cases wrong now, but I will find the exact case. It's a very good case in Dublin that I will sorry, in Dublin that I will post here. But I would just the reason I wanted to refer to the ABA is because of the work that was done on precisely this, on the use of this doctrine of abusive process. And so, Samira, maybe I will refer to you while I find the case I was referring to.
Sure. Thank you. I mean, what Charlie said is exactly what we have been finding, that generally speaking, procedural rules, whether that's specific to courts or just civil procedure laws in countries, all have some kind of protections around abuse of process or making statements to the court that are not in keeping with the purpose of the underlying law or the judicial system, right? And both of those do, in our opinion, do include SLAPPs and therefore empower judges to either dismiss of cases or treat them on a different track where they could employ some minimization tactics in terms of minimizing the impact of SLAPPs on the defendants. And what we're trying to do in that sense is to work with lawyers within different jurisdictions to encourage them to employ these procedural protections and file motions under those procedural protections. At the same time, we have been finding it has been quite challenging for lawyers to actually do that. One, as Charlie said, that is an underdeveloped area. People don't want to necessarily take the risk, right? But even when lawyers do employ those, judges are reluctant to actually view those because as first instance judges, they always know that this is likely to go on appeal, and they have their reputation at stake in terms of how they have dealt with a situation, and sort of departure from the way the established practice is always risky. So in that sense, we do think some kind of guidelines from the higher judicial authorities, whether that's judicial councils or other judicial authorities with that mandate is important. We have seen guidelines, for example, coming from the Supreme Court of Colombia on the issue. So yes, it's a journey, it's a process, but work is underway to actually start to make use of those procedural protections.
And that actually sort of dovetails with the presentation we had from Judge Biolcati around exactly that sort of guidance around the procedural mechanisms and how to manage the different aspects of a SLAPP suit. So, Judge, I don't know if you also wanted to weigh in on this, but I mean, as a US trained lawyer, I love a bit of process. So it's good to hear that's been effective for folks. But yes, what are your thoughts as well?
Yes, here in Brazil, the SLAPP, it's included in a broader concept or in a broader phenomena that we call predatory litigation. And so this phenomena, it's attracting attention from our judicial system, from our Federal Council of Justice to tackle this phenomenon of predatory litigation. So the term predatory, I think it's good to understand. So the intent of the plaintiff is to predate, to obtain something that is meritless from the judicial system. I think it's a key point that it would be good to be developed.
All right, and we are coming close to the end of our time. So I have one final question from the chat. And just to let everybody know, we do see all of the questions, and we will, I think I saw Charlie typing in one, so we will try and either answer in the chat or follow up after, and we'll also circulate some of the things that we've been referencing. So I love this question. It comes up a lot, but can you explain the difference, basically, or how SLAPPs are different in relation to criminal versus civil law, and what remedies might be available specifically for environmental defenders, but I think we've seen this across the board for those who've been slapped in both. So you've been civilly slapped and criminally slapped. What are the kind of remedies? So I think we've maybe been leaning a little heavily onto civil civil SLAPPs in our conversation so far. So could we get a little bit of, I guess, same question, what kind of remedy, but also what kind of mitigation maybe for a criminal SLAPP? And if it's helpful, maybe somebody could quickly answer the question of what makes something civil versus criminal SLAPP. The original SLAPP did not really reach to criminal, and now, of course, we do see a lot of criminal charges that we call sort of criminal SLAPP. So if someone could maybe start with that. Yeah, Charlie.
I mean, I could just very quickly say this because, I mean, Gina, you noted that conceptually the SLAPPs started in the US. And so in the US, it was really thought of as a form of privatized censorship, right? So it was a form of censorship that was advanced by a private party. And in Europe, and other parts of the world, it's much more complicated because private parties are able to, in many cases, unilaterally invoke criminal law, such as when it comes to criminal defamation. One of the first things, therefore, that we suggest is the need for decriminalization for precisely that reason, because the criminal law is an enormously powerful weapon to wield, and to threaten someone with huge sums of money is one thing. To threaten them with a prison sentence is a whole other thing. So it's a much more powerful tool of intimidation. But I think one of the reasons that conceptually there hasn't been that separation in the past is because sometimes the anti-SLAPP solutions are different, because obviously with a criminal matter, often the pursuer is a state authority, and it can be very different mechanisms. But I think often, especially in jurisdictions where there is that gray area and where private parties are able to unilaterally invoke criminal law, many of the remedies are the same. And certainly things such as early dismissal becomes even more important, especially where the process can be particularly onerous. So yes, I think in terms of that distinction, with civil lawsuits, you are talking about private parties, but that distinction can become a little bit blurred in some jurisdictions.
Thank you. And with 2 minutes to go, can I just get a final comment from each of you? And I'll start with, we'll go in the same order you presented. So starting with Professor Satterthwaite.
Thank you so much. So I think this has been such a rich conversation, and I'm really happy that we've all come together. One thing I just wanted to call our attention to is the fact that there is a larger set of dynamics going on here. So we're talking a lot about the exploitation of certain forms of procedure and certain forms of criminal law as well. But we have to remember that there's also political capture of judiciaries and political capture sometimes even of bar associations. So I think it's helpful for us to think about what's possible in each place. And sometimes it will be the weaponization of the system through capture of the system itself. And sometimes it's going to be the kind of activity we're talking about here. And so final word is, this is exactly why protecting judicial independence and the autonomy and independence of the legal profession is so crucial, just to make sure that it's available to protect the rights of all. Thanks.
Thank you. Judge.
Yes, if we're talking about strategic lawsuits against public participation, I think it's a systematic way of action. I think the response should be systematic as well. So not just individual, but systematic. I think this is the key point that we have to develop from now. And that's all for now. Thank you.
Charlie.
Thank you so much. It's been a real pleasure to be part of this panel. I would just finish by ask people to pay attention. This is a very much a dynamic debate. There's going to be a lot of developments in the months to come. There will be a number of opportunities for dialogue. It is an area which is replete of nuance, and one that we have to navigate carefully. But I do think it's one that it's important for bar associations and law societies to grapple with as soon as possible. Unfortunately, SLAPPs are a growing problem around the world. We're seeing them grow in line with the growth of populism and polarization around the world. And it's really important that bar associations are on top of this. There have been developments and there are a lot of best practices which have already been established. But as I said in my reply, I would not wait for anti-SLAPP laws to be introduced to get started on this. And likewise, I would avoid any complacent assumptions about the level of SLAPPs in any given country. One I noted during my presentation about the work of CASE to map out SLAPPs across Europe. One thing I'd note is over the last 2 years, we have seen anti-SLAPP coalitions and working groups develop in 17 different countries across Europe. In many of those countries, there was an assumption before these coalitions were launched that the countries in question didn't have a problem with SLAPPs. It was only when those cases started being mapped out that authorities, those in media and other areas started to realize there was indeed a problem. So yes, I would say get ahead of the curve, pick up on some of these best learnings, and do please engage in this discussion.
Samira.
Yeah, I'll just make a quick remark on the criminal because we don't have a prosecutor on the panel who is another of the justice system, where and in criminal proceedings, obviously prosecutors have even a bigger role to play, even if the underlying lawsuit is brought by a private party. We know that, for example, in Southeast Asia, they have laws on criminal defamation, for example, where the prosecutor has the ability to dismiss the lawsuit. But at the same time, it can be rebrought, so they have not been as effective as they should be. But there are some tools that are being developed in that, and there are certainly obligations of the prosecutors that comes into play. And in terms of the closing remarks, something that I think also the work of the increased tracking of SLAPPs has shown is that there is this shift in culture, so sort of not cool to bring SLAPPs, right? It's even in some places where no specific protection exists, SLAPPs don't necessarily they're not a sort of a major problem because there is a certain culture associated with it. So we bar associations, as well as more broadly governments and society at large, has a role to play to shift that back to that it's being litigious, especially for issues that are meant to suppress public participation. It should not be welcome, and we all need to play a role in that.
Okay, well, with that, I want to give an absolutely huge thank you to all of you for joining us, and your remarks were timely, relevant, and just, I also want to say I was prepared to ask a question about how do we make sure we're not attacking lawyers at a moment when they're already under attack, and you all seamlessly wove that through. I did not have to carve that out as a separate question, so thank you. And thank you to everybody else who joined us. We will circulate some of the materials we referenced. Please stay in touch if you're following this issue. I've seen some comments offering to put us in touch with others. It's really wonderful to know this many people care about this, and I think we're only going to see more and more effort and energy. So have a great rest of your day or evening, and stay in touch. Thank you.
Thank you.